All right, we are on the record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference and also in person. We are, or first let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Your Honor, Michael Dagger-Margosian for Mr. Lester.
All right, and Mr. Dagger-Margosian, where do we stand with Mr. Lester's case today?
Your Honor, at this point, I don't, there's a breakdown of attorney-client relationship. I can't move forward and represent Mr. Lester. I've, without getting into the details, obviously those are privileged, but it's clear that Mr. Lester either needs to move forward pro se, and I can certainly be on standby, or I can conflict this out, but our office is not going to be able to represent Mr. Lester.
Yeah, I would like the ACLU to forward. I forwarded everything to the ACLU. They already have my file and the Civil Rights Commission.
Mr. Lester, I'm sorry, but the microphone at the jail is really bad. There's a bad echo there.
Can you hear me? Can you hear me now?
Yeah, so I can hear you. The issue is if you could talk not quite so loudly, because it's an echo in the room that causes the problem.
I'm in the ACLU and the Civil Rights Commission already are on this. You can move my file to those. They already, I have sent them my complaints. I've also got the failure to appear, what I was picked up for in the first place, was dismissed. And Mr. Margosian is trying to move forward with a trial, and I'm not feeling that. I want to move for an immediate dismissal because I was harassed for 3 days.
Welcome back, everyone. Today we are diving into a pre-trial hearing that's equal parts legal procedure and courtroom chaos. The case? People versus Donald Raymond Lamont Lester. On the surface, it's a simple pre-trial, but the drama begins almost immediately. Mr. Lester's attorneys have essentially washed their hands of him, citing a breakdown in the attorney-client relationship. That means he's either going to navigate this process on his own or wait for outside organizations like the ACLU to step in. And from the very start, you can see the classic hallmarks of a sovereign citizen-style defense: buzzwords, paperwork, and claims that the system is harassing him. Will these legal maneuvers fly in front of the judge, or are they about to hit a hard reality check? Buckle up, because this is going to be a fascinating mix of procedural law, personal rights, and courtroom tension.
And they already have wind of this. There should be they should be asking for the body cams from August 2nd. As well as the 4th. I still haven't went over any evidence. So the Civil Rights Commission has my paperwork and my affidavits rather, and the ACLU is on standby as well. I just rather for my whole file to go to them and let them represent them, let them take a look at what's going on. I don't have any transcripts. I haven't talked to Ms. Margosian since then. I had to have the jail email the courts for a court date because I've been sitting here for so long. Like I said, the failure to appear got dismissed. That's what I was picked up for originally.
Okay, so Mr. Lester, you've been charged with possession of methamphetamine and 2 counts of assaulting, resisting, obstructing a police officer. You have previously been represented by the public defender's office, and they are requesting to withdraw as your attorney at this point. If that were to happen, another attorney would be assigned to you.
I just said the ACLU. I don't know what part of that nobody understands, but the ACLU is on standby as well as the Civil Rights Commission. I said it again.
Here's where things start to get wild. Mr. Lester is adamant that the ACLU and the Civil Rights Commission handle his case, claiming harassment and a wrongful pickup. The courtroom, however, doesn't work that way. Even if he feels wronged, filing complaints doesn't automatically substitute for legal representation. This is a key teaching moment. The courts are about process, not perception. The judge is already establishing control, letting Lester know the law doesn't bend to declarations or personal indignation. You can almost see the tension building. The judge calmly stating the facts while Lester ramps up the emotion, demanding representation and asserting his rights. The stage is set for a showdown between belief and procedure.
All right, so Mr. Lester, That is not an option that I have, to send this
Okay.
case over to the ACLU. If you want the
I
ACLU,
do though, because I do though. So let's get that understood. Now I have that opportunity to do that, and I'm requesting that on record.
okay, you can request that, but the court is not in a position to do that. If you want someone else to
I am,
represent,
sir. That's what I'm trying to tell you. It's not simple as you just putting the case together and sending it to him. It's not even you. Mr. Margosian can do it. It's not even your office that needs to do it.
Mr. Lester, please don't interrupt me when I'm talking to you.
Right. Here we go.
All right. Right now, the public defender's office represents you. I'm going.
No, they don't. He just said he didn't want to represent.
All right, Mr. Lester is off camera. I don't know whether he's still in the room.
I'm standing right here. I can hear every word. I'm here as a third-party intervener and a special appearance.
This part is crucial. Mr. Lester continues to insist that the ACLU step in, but the judge points out a fundamental truth. The court can't just forward the case to them. Representation requires an official appearance on record. Until that happens, Lester is navigating a very narrow path. Hire a private attorney, accept a public defender, or represent himself. This is a classic trap in sovereign citizen cases. The belief that paperwork or external organizations can magically replace formal court procedures. And for viewers wondering, no, the judge isn't being unfair. This is the literal framework of the justice system. It's about formal filings, deadlines, and official appearances, not just intent or moral argument.
All right, Mr. Lester, are you in agreement with Mr. Dagger Margosian's request to withdraw from your case?
That's on him. Like I said before, I wanted to go to the ACLU or the Civil Rights Commission. I'm going to say it again for the court of record. They are on standby. They already know about all of this. I shouldn't have never been picked up in the first place. I was harassed for 3 days. 3 days. And you have the transcripts right there in front of you when the officers admitted that they just wanted me. And it's in the police report.
Mr. Lester, I need a yes or no answer to the question of whether you are.
Again, that's on him.
Mr. Lester, I've muted your device, Mr. Lester, because you are being disruptive and you are not allowing this court process to continue. I'm going to give this one more opportunity. I'm going to unmute your device. I'm going to ask you the question. If you don't answer, or if you continue with this disruptive behavior, I am going to hold you in contempt and sentence you to 93 days in jail.
Very unprofessional.
Mr. Lester, are you in agreement or are you not in agreement with Mr. Dagger Margosian's request to withdraw as your attorney?
Well, if you please, yeah, I'm in agreement. If you please send that file over to the ACLU, please.
Check out the courtroom dynamics here. The judge is forced to mute Lester's device due to constant interruptions and disruptive behavior. This is where the balance of authority becomes evident. No matter how passionate Lester is about his claims, disruption carries consequences. Contempt of court isn't arbitrary. It's a safeguard to maintain order and fairness for everyone involved. And notice how the judge communicates clearly and repeatedly. Answer the questions, stop interrupting, or face a sentence. This is a textbook example of courtroom management in action. It's fascinating because while Lester believes he's in control, the reality is that authority always resides with the judge, not the defendant's narrative.
I'm in agreement with that. Mr. Margosian, are you in agreement with you? Send that over to the ACLU, please.
Can I get like a contact information? I mean, I don't just send a file to
You
the
know,
ACLU.
okay, yeah, but you know where the ACLU office is. I can get that to you. Yes, no problem. You can go off screen and I can get that to you. I have it right here in front of me. No problem. No problem.
And if that for whatever reason, I mean, that's outside the norm of
Man,
what
I'm not. It's as simple as
All right.
knowing my rights have been violated. You know that. We're not going to keep going back and forth. I'm not doing it.
All right.
I'm tired of this.
Mr. Lester, please stop. So Mr. Lester has consented to Mr. Dagger Margosian withdrawing as his attorney. If there's some arrangement for Mr. Dagger Margosian to send information to the ACLU, that is, the court has no control over whether he is going to do that, and the court has no authority to require him to do that.
And Your Honor,
What the court
Playing games, man.
What the court is required to do under this process is to provide for the appointment of a special public defender. If Mr. Lester can get the ACLU to represent him, then you need to make arrangements to do that. And if there's an appearance filed by the ACLU, then they are welcome to represent him. But as it stands now, he is without attorney, and the court will make the appropriate arrangements to have a special public defender appointed. If the ACLU wants to substitute in place of that person, they are welcome to do so.
Yeah. I also like for a PR bond. I've been sitting here almost 180 days. My bond is ridiculous. My family's not going to be able to pay that.
Here's where the signature sovereign citizen patterns emerge. Lester's filings are full of buzzwords like third-party intervener, special appearance, and civil rights violations. If you've watched other cases like this, you immediately recognize the playbook: mountains of paperwork, confident assertions, and attempts to outmaneuver the court with technicalities. Unfortunately for him, none of this carries legal weight without formal procedures or recognized filings. The court is about to demonstrate a harsh reality check. Legal systems rely on structured, verified processes. Enthusiasm, frustration, or ideological belief does not override statutory requirements. This is the moment where the illusion of control collides with legal reality.
All right, I will adjourn this case to February 7th.
I'm requesting a bond, please, for the court of record.
Mr. Lester, let me do one thing at a time. You're constantly interrupting me.
I'm just tired, man. I'm tired. Mr.
Stop interrupting me, Mr. Lester.
Damn. How did it, man?
Pretrial is adjourned to February 7th at 8:15 a.m. Mr. Lester has made a request for a personal recognizance bond. Court has addressed the issue of bond with Mr. Lester numerous times previously. My decision on bond and reasons for it at this point have not changed.
Supposed to be professional. Racist.
Mr. Lester currently has a
Too expensive, sir. Too expensive.
Mr. Lester currently has a $5,000 cash or surety bond in this case, and that is appropriate, in my opinion, to assure his further appearances at this court. And so I'm going to deny the request for a personal recognizance bond.
That's crazy. Because I ain't white.
Now let's talk about bond, a topic that sparks emotion in many defendants. Lester requests a personal recognizance bond, citing family hardship and his extended pretrial detention. The court denies the request, citing the original charges and the need to ensure his appearance. This is a critical moment to highlight cause and consequence. The judge carefully reminds Lester that his own actions, specifically possession of illegal narcotics, directly influence the conditions he now faces. Bond isn't about punishment, it's about guaranteeing court appearances. And for viewers, this segment perfectly illustrates how personal responsibility intersects with legal procedure. The rules aren't subjective, they are consistent, regardless of one's complaints or perceived grievances.
Mr. Marcos,
Mr. Lester. All right, you know what, Mr. Lester, stop.
No.
I muted your device, Mr. Lester. You have been warned repeatedly by me in this hearing as well as in other hearings. You are in contempt of this court as a result of your behavior here today. It's a sentence of the court that you served 93 days in the Lenawee County Jail. There's no further information that the court needs to find the contempt. It was directed in the presence of the court and after being warned numerous times. So, Mr. Lester, you can let the officer that's with you know that you are done with court for today. I will put the device in the waiting room until you are gone.